Hi, I see that some people have joined. Hi Tushar, hi Priya, Pragya, hi. Hi Raj Lakshmi. We still have about 2 minutes to go, so I shall begin then. Thank you very much for your kind words of appreciation on my selection at the ICJ. Really means a lot. Thank you. Okay, so I think the video and audio are perfect as I hear from the organizers. Hi Rachel. We still have about 2 minutes to go, so if you have any other questions prior to that, I'll be happy to answer. Otherwise, I will then come later and join. Thank you very much, Pragya. Hi, Shriya. Hello, Akash. Still have 1 minute before I begin. Or maybe we can wait for a minute or two more so that others can also join. Hello, Siddharth. Thank you for joining. Hi, Ricky. Thanks for joining. Hi, is that Samir? Thanks. Hi, Atul. Thanks for joining. Hello, Abhishek. My dad has also joined. I'll begin in the next 2 minutes. If you have any other questions, concerns, thoughts, suggestions as to how you'd like this session to be, I'll be happy to conduct it in that manner. Hi, Prapti. Thanks for joining. Hello, Mr. Advocate. I don't know your name, but thanks for joining. Hi, Snehal. Thanks for joining. Also, my apologies for my lockdown look. It's otherwise not like this, but I've tried to be as less unkempt as I can be. Hi, Yukta. Thanks for joining. Waving back at you. Okay, so I think that we should begin right now because this session will end automatically within the next 55 minutes. So, good evening, everyone. Thank you very much for tuning into this session. I'm very grateful. I hope that you and your loved ones are keeping safe and healthy during these testing times. Today's topic for discussion is the practice of international law at the United Nations. Now, why have I chosen this topic today is because during this time, everybody is thinking about how to save the world, how to address several concerns at world forums, and whether or not they are effective in tandem with international law to address the pandemic. While my session will not focus on how we can come out of this pandemic, it will run through an overview of how international law and the United Nations has in the past and will continue to help us maintain a peaceful global order. So, I am Mohit Khubchandani, and before I begin, I would like to tell you a bit about myself and why I should be the one speaking about this. I have had the fortune of being an international disputes resolution attorney, and in the past, I have served in several positions at several United Nations agencies. I have worked at the Permanent Mission of India to the United Nations in New York, and also at the United Nations Secretariat in New York at the UN Office for Coordination of Humanitarian Affairs. I am currently working as a research fellow at the United Nations International Law Commission. So, here we begin. Now, even if we look at the United Nations Charter, which was signed in 1945 at San Francisco, it is in the nature of the most powerful legal document that exists on the face of the earth. Therefore, in a sense, we could say that the very foundation of the United Nations is nothing but agreed international law norms by nations. Now, with this preface, I would like to outlay the structure of my remaining 50 minutes address today in the following 5 prongs. First, I shall spend about 10 minutes in explaining the setup of various UN committees, which is imperative to understand before we delve in further. Second, I shall spend about 15 minutes in explaining, with the help of certain examples from my experience, about the entire life cycle of international law, that is, deliberation, creation, reform, and proposals at the UN organs and other affiliated agencies. Third, I shall spend about 10 minutes in addressing the most existential debate about international law in United Nations, that whether or not such agencies are effective and whether international law in itself is adept to address the world order. Fourthly, I shall address any questions that you may have during the course of this session. And finally, and fifthly, on popular demand, I shall endeavor to give you an outlay about how to proceed in a career towards the United Nations and international law. This, of course, comes with the caveat that there is no sure shot ladder to success. Otherwise, I would have been right up there. So with this, I come to part 1, which is the introduction to United Nations Committee at the United Nations headquarters in New York. Now, let me first begin with the organs of the United Nations, which you perhaps must have heard about. The United Nations is composed of 6 organs, and 5 out of these 6 organs are situated at the United Nations headquarters in New York. The 6th organ, which is the principal judicial organ of the United Nations, is seated at The Hague in the Peace Palace at the Netherlands. This comprises of the 6 organs. Now, for the purposes of today's conversation, I shall on purpose exclude the United Nations Trusteeship Council and the Economic and Social Council because they are more of ceremonial significance in these times. Now, coming to the first organ for today's discussion, which is the United Nations General Assembly. This, in my opinion, is the principal organ of the United Nations where each and every one of the 193 members and other observer nations which are not part of the United Nations also have a seat and an equal voice. The resolutions of the United Nations General Assembly are adopted by two kinds of majorities. When questions of peace and security, budgetary concerns, election, admission, suspension or expulsion of members is concerned, then a 2/3 majority mandate is required to pass those kind of resolutions. But for all practical purposes, for today's discussion, we will be focusing on other matters which come before the United Nations General Assembly, wherein a simple majority, in other words, more than a 50% vote is required to pass a UN General Assembly resolution. It is imperative to note, however, that these resolutions do not have a binding force as do United Nations Security Council resolutions, which I shall touch upon shortly. At this juncture, though, it is very important for me to tell you how work and subject matters at the United Nations are distributed. Now, besides the 6 organs, there are also 6 working committees at the United Nations, and these are created to have a more structured functionality. The first committee is the Disarmament and International Security Committee. Treaties such as the Nuclear Weapons Convention, the Non-Proliferation Treaty, which is an offshoot of the Comprehensive Test Ban Treaty, were a result of deliberations in this committee. I must also point out that the United Nations Security Council primarily deals with the work that is performed by the first committee and the fourth committee, which I shall talk about very shortly. Now, the second committee is the Economic and Financial Matters Committee. On a personal note, however, I would like to add the word environmental in this committee because many significant resolutions and conventions which we know of are a byproduct of the functioning of the second committee. For illustration purposes, the Convention on Biodiversity, the very recent resolutions on the effects of El Niño and oceanic phenomenon were a result of this committee's deliberations. Now I come to the third committee, which is the Social, Humanitarian and Cultural Committee. This is a committee wherein I have personally had a significant experience. It is perhaps the committee which contains the widest array of topics such as education, gender, right to privacy, health, sanitation, other social issues such as terrorism or the like. Coming to the fourth committee, the scope of the fourth committee, which is the Special Political and Decolonization Matters Related Committee, is very myopic. This particularly deals with matters such as the right to self-determination and sovereign claims of nations. As I mentioned earlier, this fourth committee, along with the first committee relating to international peace and security, is primarily the mandate of the United Nations Security Council. The fifth committee is the Administrative and Budgetary Matters Committee. This is not much of a concern for lawyers as it involves issues of budgeting which otherwise may have a huge concern for the UN but not for international lawyers. Finally, the sixth committee, having the most simple name, is known as the Legal Committee. I am not sure if there is a specific reason why this is the sixth. Maybe they saved the most significant one for the end. Though, do not quote me on this. So, jokes aside, the sixth committee is essentially responsible for deliberation of all legal treaties and conventions that concern humankind and nature. Each and every international law, as we know it, has been enacted in this committee. The delegates of this committee are known as legal advisors from a permanent mission of a nation to the United Nations. I had a fortune of working in this modality as well when I was working for the Indian mission in New York. With this backdrop, I come back to the organs of the United Nations. Now, as I was mentioning, that the United Nations General Assembly possibly has the widest mandate. It therefore concerns functioning of all the six committees that I just spoke to you about. Now, it is imperative for us to understand the importance of the United Nations General Assembly in creation and development and reformation of international law. The United Nations General Assembly resolutions are reflective of what we call opinio juris and state practice, which are the two constituents of customary international law. This position was also fortified by the International Court of Justice in the case concerning military and paramilitary activities in and against Nicaragua in 1986. Now, many a time, United Nations General Assembly resolutions have converted into conventions, and many a time principles of conventions have been put to test in United Nations General Assembly for their reformation. To give you an example, the Rio Declaration on Environment was a byproduct of the United Nations General Assembly in the form of a resolution. The Outer Space Treaty of 1969 was first in the form of a resolution and then was adopted as a convention. Now, there is one more very effective tool that the United Nations General Assembly possesses. In the event that disputes cannot be adjudicated at the United Nations Security Council, in the event that there are two countries concerned which might have an impediment pertaining to compulsory jurisdiction of the International Court of Justice, then the United Nations General Assembly has the power to write to the International Court of Justice's president, recommending that it give an advisory opinion on a matter wherein otherwise the countries cannot be summoned on a compulsory jurisdictional basis. This happened in 2004 when the United Nations General Assembly requested the International Court of Justice to render an opinion on the case concerning construction of a wall between Israel and Palestine. There are a lot of talks right now about going to the United Nations General Assembly and seeking for a resolution forwarded to the International Court of Justice regarding an advisory opinion about the People's Republic of China's actions in the current COVID-19 scenario and whether the International Court of Justice would have an opinion about the same. Coming to the second organ, which is the United Nations Security Council. Now, even though it has 15 members which are elected on a 2-year term, it is still the more powerful, or in fact, if I must say, the most powerful organ of the United Nations in enforcing international law. This comes by the very nature of United Nations Security Council resolutions, which are binding in nature. Now, as you would know perhaps, that there are 5 permanent members of the United Nations Security Council: the United States of America, Russia, the United Kingdom, France, and the People's Republic of China. All these 5 members enjoy a veto status at the United Nations Security Council. Essentially, let us assume that there is a resolution which is agreed to by 14 members, but is objected to by 1 member who happens to be a permanent member of the Council, then that resolution does not pass. There has been severe criticism of this power, and people have come up with a proposal that at least the permanent 5 nations should not be a judge in their own causes. Essentially, if a topic concerns their actions or inactions, then they should not be able to exercise that veto power. Besides that, there is also a lot of debate upon the expansion of the Security Council as other world powers are emerging. Now, coming to the next organ, which is the United Nations Secretariat. This houses several UN agencies which work in tandem to propose international law to countries or to propose reforms to countries. Let me give you an example which will make you understand the relationship better between how a diplomatic mission would work at the UN and how UN agencies would supplement that work. Now, diplomatic missions, according to their national interests, propose a topic to the President of the United Nations General Assembly. That topic is then put on the agenda of the Assembly, and then that topic is taken up for deliberation. There are several informal meetings which are held in the basement of the United Nations Secretariat before they are actually voted upon at the United Nations General Assembly. So, when these deliberations are made, then certain sponsoring nations which have come up with a particular proposal about creation of international law or reforming existing principles of international law prepare something that we call a zero draft. That zero draft is nothing but a draft resolution which has operative paragraphs, which is like the preamble of a text, and then it has preambulatory paragraphs otherwise. Now, when countries sit together, they discuss these zero drafts word by word, and there are several meetings held over days, weeks, or months, depending upon the complexity of the international legal question in concern. Now, once the period for such deliberation is over, then typically towards the end of the year, which is towards the end of November, is when the final texts of these resolutions are first informally put to vote in the respective committees that I spoke to you about. Once these are adopted at these committees, it is only then that they go to the United Nations General Assembly or Security Council for a final vote. Countries are allowed to change their vote after the preliminary voting, which has not been done in the General Assembly or the Security Council. So now, where does the role of the United Nations Secretariat come in? So, to give you an example, let's say if we are discussing the topic of climate change, then countries invite UN agencies such as the UNFCCC, which is the United Nations Framework Convention on Climate Change. They might invite UNEP, which is the United Nations Environment Program, to come and participate in those closed-door deliberations to give their specific views about the issue in concern, to guide countries in preparing comprehensive texts which are also legally sound. Therefore, these agencies play a supporting role in creation and reformation of international law. With this, I come to the next organ, which is the principal judicial organ of the United Nations, the International Court of Justice, located at The Hague in Netherlands. Now, this has the mandate to adjudicate two kinds of disputes. The first is contentious disputes, wherein countries might bring, by way of a special agreement, a legal question which the court might be required to adjudicate upon. Now comes the second kind of power of the United Nations International Court of Justice, which is advisory opinions. Now here is where the congruent role of the United Nations Security Council as well as the United Nations General Assembly comes into being. In accordance with Chapter 7 of the United Nations Charter, the Security Council can recommend to the International Court of Justice to render an advisory opinion on a topic that concerns international peace and security. So does the United Nations General Assembly have that power. In the past decade or so, there has been a pleasant sea of change in the attitude of countries reposing trust in the International Court of Justice as a mechanism to give international legal justice. Coming to other organs, and I would definitely address this because I currently work here. This is the United Nations International Law Commission. Even though this does not compose one of the 6 parts, the 6 organs of the United Nations, however, this mandate comes from Article 13.1 of the United Nations Charter. As per the Charter, the International Law Commission was composed to render progressive development and codification of international law. It has 34 highly qualified publicists, academicians, diplomats, and practitioners of international law who supplement the working of the United Nations. The sessions of the International Law Commission are held from April to August every year at the Palais des Nations in United Nations, Geneva. Now, with this, I come to the third part of today's discussion, which is to address the existential debate about whether or not UN agencies are effective, whether or not the international legal system in itself is effective to address the current world order. Now, this entire debate can actually be answered by one famous quote by the Second Secretary General, Dag Hammarskjöld, of the United Nations. He said, I quote, "The United Nations wasn't created to take the mankind into paradise, but rather to save humanity from hell," unquote. You might have gotten the sense of what is to follow in this part, yet I think it will be important for me to look at this from a twofold prong. Now, whether we look at the United Nations from a monist international legal perspective, which speaks of inclusions and conglomerations of municipal and international laws, or we look at it from a dualistic and more dogmatic way, which is an exclusionist way of looking at the international legal perspective, is something that I believe is a personal choice and very subjective. However, in my personal opinion, the best way to settle this debate is to see that A, whether the UN has done more good than harm since 1945, and B, whether international law and its applicability bolsters the global order or weakens it. Now, if these two questions can be answered in the affirmative, then it would be safe to say that we are in indeed safe hands, and that the congruence of United Nations and international law is towards a better and peaceful world. The best way to answer these questions is through some illustrations that I have just jotted down. Now, if we look at the liberal viewpoint, which was propounded by Immanuel Kant, the UN has been able to contribute a lot towards peacekeeping and health efforts. There have been several successful peacekeeping missions, and to name a few, those being in Namibia, in Central America, in UN, Iran, Iraq observer military groups, to name a few. These days, a lot is being said about the World Health Organization and its criticism. But I ask myself this, that has the WHO not helped in successfully eradicating diseases such as smallpox or tuberculosis? It indeed has. Therefore, we may have our reservations, but there is good work being done. If we think about human rights, then the UN Human Rights Council has promoted a lot of issues like homosexuality, torture, women and child rights. Because of the proactive movement of the UNHRC, there were mass liberalization movements in the UK and US in the beginning. In countries such as Afghanistan, Lebanon, Sudan, the former Yugoslavia, UNICEF worked towards opening corridors of peace for providing vaccinations in terms of testing times such as armed conflicts. From a legal standpoint, the International Court of Justice's work has been instrumental in promoting world peace. Even other UN tribunals such as the ICTR and ICTY have played a significant role in dealing with issues pertaining to crimes against humanity. In September 2019, Latvia became the 75th nation to accede to the compulsory jurisdiction of the International Court of Justice, which only showcases the increasing faith in this international legal organ of the United Nations. As most of my audience seems to be Indian, it is imperative for me to point out the recent Kulbhushan Jadhav case, which was adjudicated by the International Court of Justice, wherein India alleged violations of the Vienna Convention of Consular Access and said that Pakistan should treat Commander Kulbhushan Jadhav with the respect that he deserves and that he be allowed consular access. Now, if we didn't have this mechanism in place, then I wonder how such a remedy would have actually been possible through the domestic legal recourses. Therefore, I can say without any hesitation that there might be scope for improvement, but this world order is imperative for us. Now, I have reached part 4 of our discussion, which brings me to the questions which people might have today. So, I already have one question in advance from Rudra, and I'm going to begin with that. And if there are other questions in the meantime, I will try and address them impromptu, which might lack accuracy, but I will try my best. So the first question, and a very great one at that, thank you very much, Rudra, for that question, is that what is the scope of preemptive self-defense in today's world with reference to the US airstrikes on Qasem Soleimani, the military commander of Iran, and what role can the UN play? Now, if we turn back pages of history, this question came into being with what we call today as the Bush Doctrine. In the aftermath of the 9/11 attacks on the World Trade Center in New York, the United Nations resolved that it had the right to secure itself against countries that harbor or give aid to terrorist attacks, and it justified this Bush Doctrine as it was enacted with the then 43rd President of the United States, George W. Bush, to justify the 2001 war in Afghanistan, the 2003 invasion of Iraq. Now, from the standpoint of customary international law, in accordance with Article 51 of the United Nations Charter, preemptive self-defense is allowed in very limited contexts. It is only when, as per Article 2, Clause 4 of the United Nations Charter, there is either a use or a threat of use of force, and this too is mostly construed in the context of armed attacks. Therefore, if we come to the question of Qasem Soleimani's assassination by way of airstrikes, It is my opinion that the United States government has been unable to explain the killing of General Soleimani. It has been unable to provide tangible evidence as to how Soleimani, as a person, could have been a threat upon the upon the United States. This position is different from the killing of Osama bin Laden or the killing of other non-state actors. However, since Soleimani was a state actor, then essentially the United States acts are squarely against the sovereign rights of Iran. To give an example, how international law can be effective in such situations is the example of the invasion of Iraq in 2003. Now, United Nations Security Council Resolution 687, and as was also pointed out by the International Court of Justice, was that the US was unable to justify its acts of invasion. Now, the US, whether it could justify itself or not, had to at least give an explanation and not be absolutely scot-free. Even in the current situation, if there were no international legal systems or no United Nations, then countries would do as they please. So this is my take on this question, and I have another question right now from Sanya. Hi Sanya. So Sanya says that, as you pointed out, the Kulbhushan Jadhav case, could you throw some light on it as of today? What has really ensued in that effectively? Now, I am as incapacitated as perhaps all of you listening to me are in terms of what is really going on in Pakistan right now with Kulbhushan Jadhav. There has been some consular access, and Indian diplomats were in fact allowed to meet Kulbhushan Jadhav only after this verdict, even though it was through closed doors. There has been an undertaking by Pakistan to give another trial to Commander Jadhav, which was erstwhile not being allowed, and it was a final judgment given by a military tribunal which is not appealable. I would like to be positive about this situation. There is a lot of diplomatic note verbal process that is going on between the nations, and I can only hope for the best. And as I said, that this was a process to initiate something that might bear fruition. So that was something that I believe was achieved through this decision. Now, I have another question from Rachel, which says, what roles does diplomacy play in recognition of states such as the present conundrum of Taiwan's recognition by India as the next WHO head? Now, recognition comes in two ways. One is a de facto recognition, and the other is a de jure recognition. There is a convention known as the Montevideo Convention of States, and it has 4 criteria for a state to be recognized. The first is a well-defined territory. Second is a population. Third is an effective government. And fourth is people, or the will of the people to be associated and to be named as part of that entity which they call a country. Now, in the case of Taiwan, there are separate laws that actually govern the functionality of Taiwan, but there is a lot of pressure by the People's Republic of China to recognize it as a part of China. If tomorrow an overwhelming majority of countries make an unequivocal statement that Taiwan be recognized as an independent nation, then they have the power to deal with Taiwan in the capacity of it being a nation, whether or not the People's Republic of China may think otherwise. Now, I am not capacitated to answer the next prong of the question as to who can be the WHO head, because that's more about politics and diplomacy. But I hope that I have been able to answer the question of recognition of Taiwan and the question by and large of recognition of states. So I can perhaps take one more question and then I will come to the final part of today's presentation. And this question comes from Simran Bakshi. Hi Simran. Simran says that, could you please shed some light on the role of Gambia in the recent ruling of the ICJ against Myanmar? This is a very interesting question, Simran. Now, the reason why Bangladesh was not able to prosecute Myanmar is something that I'm going to elicit first. This is because Bangladesh has a restriction in terms of its compulsory jurisdiction before the International Court of Justice. Therefore, perhaps because of good relations with Gambia, the Gambia, in a sense, on behalf of Bangladesh, filed that case. And this case was sustainable because there is a very beautiful notion of international law, which is that countries need not be directly affected in order to institute proceedings at the International Court of Justice, even if another country is violating norms of conventions that they are a party to. So in the case of Bangladesh, since it was not a part of the 1951 UN Refugee Convention, that is why it could not prosecute Myanmar and take use of that convention. Whereas the Gambia was a part of that convention, and therefore it could go in for provisional measures, and that is the stage at which this hearing is at, and ask Myanmar to tell the court about what measures they are taking in this regard. So I hope that I've been able to answer this question, Simran. And with this, I come to the final part of my presentation today, as I'm left with only a few minutes. And this is on popular demand, and this is a question about how to get into the United Nations. Now, the smile on my face can tell you that this is perhaps a tricky one. So it is not an easy path to tread on, especially if you are an Indian. And I say so not because of any other reason, but because of logistical reasons. Neither are we the biggest funders of the United Nations, nor are we the big beneficiaries of UN funding. Therefore, Indians find themselves sandwiched in these pole positions, and what we get in terms of positions is restricted in that sense. It is also imperative to note that despite being native English speakers, our other language skills are not something that would be encouraging for a typical UN application. So on this note, in fact, I would encourage all of you to at least be proficient in languages such as French and Spanish. And not that I am there yet, but I am endeavoring to get there. So I will actually throw in a cliche quote that I follow in my life, which is from Rocky Balboa. And I quote, "It ain't about how hard you can get hit. It's about how hard..." I messed it up. "It ain't about how hard you can hit. It's about how hard you can get hit and keep moving forward," unquote. Essentially, I mean that we can pursue this by writing papers which are of concern to the United Nations. We can take part in moot court competitions which involve simulations of UN agencies, of particularly the International Court of Justice. We can pursue a master's which has a focus in international dispute resolution or public international law. And then, by way of acquiring such skills, we might have to, despite our experience, first apply for internships, and then we can hope to get into the UN circle. I can tell you from my personal experience that despite having had a 3 years of working experience and having had a master's, I still had to first do an unpaid internship at the United Nations, and then I got a consultancy. And right now, the road for me also is far ahead. So I'm with you in this road. And yes, I actually have another question. And since I have 2 minutes, I can quickly try to answer this. Dipali asks, do you think the veto power used by Russia in the case of Venezuela was rightful? Absolutely not, Dipali. And I don't even think that that this is something that is of deliberation. As I mentioned earlier, that the veto power is something that is increasingly being misused, and I can only hope that good comes out of UN Security Council reforms, and specifically India has been trying a lot in this regard. With this, if there are no more questions, I think I can conclude my session as it's my time. It has been an absolute honor, absolute privilege to be having this live session with you all. I used to feel a bit guilty about not being able to share my experience with the questions that I usually receive, and I am sometimes unable to respond, but this was a great opportunity bestowed upon me by Desi Kanun, and I'm thankful to you for this. If you have recommendations for other topics that I might be able to give sessions on in the future, it would again be an absolute honor to be conducting such sessions. Thank you very much. Stay safe, stay healthy, and have a great weekend.